This pandemic has changed the world. Margaret W. Wong and Associates, with over 40 years experience in U.S. immigration law, keeps working for you in the midst of adversity. Offices are in Cleveland, New York, Memphis, Atlanta, Columbus, Raleigh, North Carolina, Nashville, Chicago, and Minneapolis. Look after your loved ones and we'll take care of your immigration needs. Please call us at 216-279-3984. That's 216-279-3984.
Hello, everybody. My name is Juan Carlos Brando, and we are transmitting from the offices of Margaret W. Wong. Thank you so much for joining us today, as every Thursday at 12:30 p.m. Eastern Time of the United States of America. And thank you for this opportunity that the law firm is giving to everybody to ask their questions live, and so that we can have an answer for many concerns, many issues that we have regarding to the immigration field. So thank you so much. We have the attorney Francis Fungson today, who is one of the main attorneys. He is, I have to say, he is amazing. The knowledge that he has is very, very good. So we can enjoy talking with him and asking him a lot of questions regarding to the immigration field. Thank you so much, Attorney Francis, for your having us today, for your time. How are you feeling today?
I'm good. Thanks for having me here, Juan Carlos.
Thank you so much, Attorney Francis. And well, the immigration atmosphere right now is focused a little bit in the southern border. So what is the main concern about the situation in the southern border of the United States, and what can the government do to control the situation there?
Well, it is a difficult situation because there are families, women and children who are fleeing difficult and very dangerous situations in their home country, whether it's Honduras, El Salvador, Guatemala, and Mexico. And so they're making this journey to the border to try to seek a better life or protection. Now, the US government is trying to find a way to help these individuals, but also maintain the security of the border. And so the procedure now is, if you arrive at the border and you declare that you have a fear of returning to your home country, you are given the opportunity to go through what's called a credible fear interview to determine, do you have a fear of persecution of returning to your country, and is it believable? Okay. If you pass that credible fear interview, then you have the opportunity to be allowed into the United States to pursue your case. At this point, there are a certain number of people who are allowed to enter the United States, but not everybody can be allowed to enter. And so there are what are called migrant protocols to determine who can enter and when. So these situations keep changing every week, and hopefully we have a way to help these people in the future.
Thank you so much, Attorney Francis. So let's talk about this scenario. If I am coming from the southern border, I am paroled in. What should I do after I am in the United States, paroled, and they give me I don't know if it's an NTA, or they say that the court is gonna send me the NTA. What is the next step in the legal aspect that I should take in order to regularize my situation in the U.S.?
The important thing is that if you are allowed into the United States to pursue your case, that you always let the immigration service and the immigration court know about your current address. That way, if the court mails you a hearing notice, when you have to show up to court and where, you actually receive that notice and you do go to court. We see this all the time where the address is not updated, the court sends a notice to maybe an old address, and then the foreign national never shows up to court and gets a deportation order, what's called an in absentia order, because they didn't go to court. So that is the most important thing. Make sure you keep your papers and maintain your address with the court so that you get any mail.
Okay, thank you so much, Attorney Francis. And if you have any questions, please feel free to write them down in this Facebook Live. This is a Q&A session that lasts 30 minutes. So please, if you have any questions, write them down right now, and we will be answering them with the Attorney Francis Fonsang. Or you also can call to this phone number, 216-279-3984, 216-279-3984. And I want to remind everybody that the law firm is going to travel to the city of Chicago on June the 8th. On June the 8th, the appointments, the consultation will be in person. So you can call right now, 216-279-3984, 216-279-3984, and you can make your appointment in the city of Chicago. Also, in the city of Nashville, Tennessee, the law firm is going to be there on the 14th of June. 14th of June, they will be in the city of Nashville, and you can make your appointment right now calling the phone number 216-279-3984, 216-279-3984. And well, this is going to be the first time that the law firm is traveling to our offices. It's been a tough year. It's been very difficult year and 2 months that we couldn't travel to the offices in other locations. But now is the time that many people are getting vaccinated, and Attorney Margaret Wong and the attorneys in the staff are being vaccinated. So we are safer to receive people in our office. Just keep in mind that you need to wear your mask, and that we will be having our biosecurity measures, the social distancing and everything, but we will be there in person for your comfortableness. It's very good to have someone talking to you in person. So, Attorney Francis, let's begin with the questions today. And this question here is: I am in removal proceedings. I appealed to the BIA. I have no criminal record, and I have U.S. citizen wife and kids, and living in the U.S. since the last in the century 1920, the 19 years. I never left the country, and good moral character. Do I have any chance to stay in the USA if BIA denied my case? Please advise. Thank you.
Well, it depends on what case was denied and what you are appealing to the BIA. If you are applying for cancellation of removal or 10-year cancellation, and the judge denied that case and you're appealing to the BIA, and the BIA dismisses that case, then you'll have a tough time trying to win that case. It might be that we might have to do what's called consular processing. That means if you are not eligible to apply for your green card in the United States, then we might have to apply at the US Embassy in your home country, okay? And that means that if you leave the United States to apply at the embassy, you'll have to apply for a few different types of waivers to forgive, number one, the deportation order, and that's on an I-212 waiver, and two, the unlawful presence for the past 19 years you've had in the United States, and that's on a form I-601. So you would need both waivers approved before you can get the visa to come to the United States and get your green card, okay? And the waivers, it's all about the hardship that your wife would have if you had to leave the United States permanently. It has to reach the level of extreme hardship.
Okay, thank you so much, Attorney Francis. I assume that this may be a cancellation of removal. Probably it could be any case, but thank you for your recommendation and your answer. Um, Please don't forget that we are live right now with the attorney Francis Fonseng, and you can ask any question and he will be answering to you. So this next question that we have right now is coming from a person that is writing this. Hi, Margaret, or hi, attorneys. I have 33 years old son that used to live in the United States for 12 to 16 years old. In his 16, he was in jail because of a fight with a friend. And after 24 hours that the cops arrested him in my home, I found him, but he was convinced to say he was guilty. And that time I was worried and I ended sending him back to Brazil. Right now, he is there in Brazil taking law classes. He's married, he has 3 kids. I filed his papers with his family to get the green card 3 years ago. I am a citizen of the United States. What should I wait now? Will he be granted to come back to the US?
So he's 33 years old, and it sounds like you filed the I-130 3 years ago. Now, because of the quota system, there's only a limited number of people who can get their green cards from each country each year. And so he might have to wait a few more years in line before his priority date, which is the date that you filed the I-130, when that becomes current and he can apply and get his visa. Now, once his place in line comes up, is he eligible to get his visa? Well, that depends on what kind of criminal record he has. So I would recommend that you get the conviction record so we can see what he actually pleaded guilty to. If it was something like assault, sometimes we would need a waiver of that assault conviction, and sometimes you don't, okay? Now, it was a long time ago. It was when he was young. So it's possible that it's not going to cause a problem for him now. But we do need to see that conviction record so we can make sure.
Yes, this person is adding something, Attorney Francis. She's saying, my son has tried the visa for him and his family, but for about 3 times, and they had been denied. I think it's a tourist visa that they have tried.
Okay.
Yeah.
Well,
So,
anytime you have spent time illegally in the United States or you have a criminal record, the embassy will give you a very tough time for tourist visas. It's not easy to get. A lot of people want to try to come to the United States. You'll have a better chance when you're applying for the immigrant visa based on your I-130 petition.
thank you so much, Attorney Francis. Don't forget, everybody, that the law firm of the attorney Margaret W. Wong has offices in 9 cities of the United States: in Atlanta, Chicago, Columbus, Cleveland, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is 216-279-3984, 216-279-3984. So this next question right now is, hello, my in-laws are illegal immigrants in the United States since 1997. Father-in-law has social security number and driving license. Mother-in-law don't have anything. Their son is U.S. citizen. How can I get them a green card or work permit in the United States?
Okay, so in general, a U.S. citizen's son or daughter who is over the age of 21 can petition for each parent for the green card. Now, the big question is, are the parents eligible to apply for the green card in the United States? And that all depends on 2 things. Number 1, how did the parents enter the United States? Did they enter legally or illegally? Okay, if they entered legally, then the son should be able to petition for both parents, and they should get their green card without a problem. If they entered illegally, that makes it much more difficult. If they entered illegally, then we have to see if there's an exception to the rule where somebody who entered illegally is not able to apply for the green card in the United States. And then we would have to look at what's called 245I. Has anybody ever filed any petitions for either parent before April 30th of 2001? Then they might meet an exception for the illegal entry. Okay.
Okay, thank you so much, Attorney Francis, for this answer. We have a lot of questions coming in today. So thank you so much for each answer. Don't forget that you can call the phone number 216-279-3984, 216-279-3984. And the next question that we have here is I'm looking forward to work with you in my case. Thank you so much. But this person doesn't have the question written here. This next question is, hey, I have questions. My wife is citizen in the United States, so I apply for I-130. How long will it take to get approved? This person is from Nigeria.
Okay, so when you apply for the green card, there's two different applications. One application is the I-130, which is the relative petition based on the marriage. Is this a real marriage? Do you two live together? The second part is the actual green card application or the visa application, and that's the I-485 or the DS-260 if you were going overseas. So if you're filing the I-130 by itself, then sometimes the Immigration Service will schedule an interview and sometimes they will not. It usually takes maybe 10 months for the Immigration Service to process an I-130. It could take longer because of pandemic-related slowdowns, okay? But at least 10 months.
Okay, thank you so much, Attorney Francis. And please don't forget that our attorneys will be in the city of Chicago on the 8th of June. June the 8th, they will be in Chicago. June the 8th is going to be a Tuesday. It's going to be a Tuesday, so please make your plans. Take that date, call the office, make your appointment, and you will have that in-person consultation with our attorneys in Chicago on June the 8th. So please call. The phone number is 216-279-3984, 216-279-3984. And thank you for contacting us today. Attorney Francis, this next question is about employment-based visa. This person says, I have been working building kitchens, Italian style, in Colombia for 12 years, but I don't have a degree. I have pictures, I have the plans, and I have everything, the design. I design them and build them according to the needs of the client, of the customer. Can I apply for any employment visa?
Okay, when we talk about employment visas, there's two different categories. One is a temporary work visa to come here on the work visa. Another way is the green card, permanent residency, okay? If we're talking about temporary visas, you usually need an employer to file a petition for you to come to the United States, okay? And for designing these kind of things, unfortunately, it's probably not specialized enough for the H-1B, and you do not have a degree, so you might need what's called an O1. That's for somebody of extraordinary ability. There are certain criteria you have to meet. Have you ever won any awards? Was your name mentioned in newspapers or magazines because of your work? Have you been publicized in the media or anything like that? Okay, anything to show that you are near the top of your field, whatever that field is. but you would need an employer to file a petition for you. On the green card side, same thing. An employer could sponsor you for the green card and have to go through what's called labor certification. That's an advertising process where the employer sees if there are qualified US workers to do the job here in the United States. If no qualified US worker is found, then you get to move forward with the green card process. Now, there's also an option to self-sponsor based on extraordinary ability, similar to the O1, but this is for the green card, and that's for the EB1A, person of extraordinary ability. If you've won awards or been mentioned in the media, have your work publicized, you can show that you are a person that you're the top of your field, whatever that field is, and try to self-sponsor that way so you do not need a job offer from an employer.
Thank you so much, Attorney Francis. This is a very interesting question, and thank you for asking those questions, because we have different people that listen to our Facebook Live show every week. So thank you for asking those questions. And our Attorney Francis is one of the specialists in the employment-based visas. So thank you so much for this question. This next question, I don't know if it's going to fit in the screen because it's quite long. But this person says, I have a friend who has been discriminated against at work. She tried to branch out on her own, but now fears retribution. And she's not exactly documented. The business owner is well connected here as well as back home. So she's kind of stuck with them and the discrimination and harassment. There's a recent case of some employees who tried to work with a competitor after quitting, and they were almost sent to prison. And they made to sign a letter giving up their career in the industry. In their industry, let's see, I have the rest of the question here. As a condition to drop the charges against them. This was back in her home country. She fears for herself here as being reported and her livelihood destroyed, as well as her family back home, which depends on her. Is there anything that can be done for her to get full legal status to get out of this situation?
Well, unfortunately, that's somebody who has somebody who is undocumented without legal status doesn't have the same employment rights that someone who is legally allowed to work here. So it's not as simple as reporting employment discrimination to the federal government or filing a discrimination claim, okay? Now, it's possible that she could explore what's called a U visa, which is for victims of certain crimes. If she's a victim of a certain qualifying crime and she reports that crime and agrees to help law enforcement with their investigation, and the law enforcement agency agrees to sign the U visa application paperwork called a Supplement B, then she could try to apply for this U visa to get legal status here. But the qualifying crime has to be on the U visa list, okay? So depending on the specific situation of what happened to her, has she been threatened? Can she document the threats? Is this something that she can report to law enforcement? And will law enforcement agree to sign the paperwork? That's something that we can explore.
Thank you so much, Attorney Francis. And this is very, very interesting what this person is going through. So please, if you need more advice, call the office. The phone number is 216-279-3984, 216-279-3984. So this person that is sending this question, he wants to stay private. And his question is the following. I am living in Colombia at the moment, in the city of Bogota. I am from Venezuela. I came here because of the situation in my country. But now Colombia is in crisis. It's in a crisis, and we don't know what's going to happen. It looks like the same kind of government that is in Venezuela is going to be installed here. However, we have been victims of xenophobia, and which is happening in many countries of South America, especially Colombia, Peru, Ecuador, and even Chile. So we have no other countries to go. And I've heard that also in Mexico, there's a lot of xenophobia against Venezuelans. Is there a chance that I could go to the United States and request a parole in the border? I've been told that they will let me go in and that it shouldn't be a problem. My question is, I've been living in Colombia for 3 years and now this situation.
Okay. So if you are experiencing persecution, whether it's threats or harm, and you fear that situation, now you can't apply for asylum unless you are in the United States. So if you want to try to apply for asylum, then you have to get to the US border, okay? And like we mentioned before, if you arrive at the US border and you declare that you have a fear of returning to your home country, then you have the opportunity to get a credible fear interview where you are interviewed by an immigration officer to determine, do they believe you, and do you have a fear of persecution of returning to your country? Now, if you want to try to apply for a visa, it's going to be very difficult because a lot of people are trying to come to the United States and a lot of people are getting denied for tourist visas. Applying for parole is very difficult if you don't have some connection to the United States, whether it's to get medical treatment here, or if you have a relative here who needs assistance, some sort of humanitarian situation. So the best chance you have is probably you would have to actually be at the border to apply and request asylum.
Thank you so much, Attorney Francis, for this answer. Please don't forget the phone number is 216-279-3984, 216-279-3984. This next question is, I have been coming to the United States with a tourist visa, and since in my country they are not putting the vaccine, I would like to see if I can go to the city of Miami, Florida, because the mayor said that the tourists can get the vaccine there. Is that something I could do? Thank you.
Okay, so if you have a valid tourist visa, then you can visit the United States, okay? As long as the visit is temporary in nature and you plan to leave, then you should be fine visiting the United States. Depending on what state you are in, what city in the United States, there are different vaccination eligibility. For example, in Ohio, anybody can get a vaccine regardless of immigration status. So you can definitely try. And the key is that you are only visiting the United States. You don't plan on staying here permanently, and you should be okay.
Thank you so much, Attorney Francis. And yes, so let's go to the next question. And I think we are running almost out of time. But this person says, we already went to the biometrics and 2 interviews. We have the last hearing this year, but I think the courts are closed. However, we have not received any notification that we have a change in our hearing date. I would like to know if there is a way that I can know how my I-130 is going and if I will have any other interview for my case. I don't really understand this question.
Well, it seems like there are 2 different parts to this case. There's an I-130, and maybe there's a hearing, like a court, immigration court case for deportation proceedings, okay? Now, if the I-130 has already been interviewed and you don't have a decision yet, you can check the case status of that petition on the uscis.gov website by checking that case number, okay, and it's online. If you're looking to see whether you have a hearing date in the future in immigration court, then either you can look online or you can call the 1-800 number for EOIR, that's the Immigration Court Hotline, to determine when your next hearing date is. Now, most of the courts have already opened now. The few remaining courts should open in the next month or so. And so if your hearing date is a few months in the future, then it's possible it can move forward. But you should keep checking that 1-800 number just to make sure, because a lot of courts now, they're moving these dates around based on different priorities, so they might cancel or reschedule your hearing date.
Okay, thank you so much, Attorney Francis. Our time is up. Well, I hope to see you soon. It's always a pleasure talking to you, getting a lot of good answers, good knowledge. And of course, we miss Ms. Wong when she's not here, but when we are here with you, it's always awesome as well. So thank you for sharing your knowledge and for giving us so many good answers.
Okay, you're welcome. Thanks for having me here.
Thank you so much. And for everybody who has joined us today, please don't forget to call 216-279-3984, 216-279-3984. And the office of the attorney, Margaret W. Wong, will be traveling to the city of Chicago on June the 8th. So please call and make your appointment for your consultation in person. It's going to be in person. This is awesome. After a year, we will be traveling again and doing in-person consultations. The phone number is 216-279-3984, 216-279-3984. And also the city of Nashville, we will be there on June the 14th. And the phone number that you need to call is the same, 216-279-3984, 216-279-3984. My name is Juan Carlos Brando. See you next time. Take care. Have a good weekend. And please get in touch with us if you need immigration advice. See you next time.
This pandemic has changed the world. Margaret W. Wong and Associates, with over 40 years experience in U.S. immigration law, keeps working for you in the midst of adversity. Offices are in Cleveland, New York, Memphis, Atlanta, Columbus, Raleigh, North Carolina, Nashville, Chicago, and Minneapolis. Look after your loved ones and we'll take care of your immigration needs. Please call us at 216-279-3984. That's 216-279-3984.